Welcome to CPA Australia's Sound Business, podcasting for business and the accounting profession.
Welcome to today's podcast. My name is Mark Morris and I'm a Senior Tax Counsel with CPA Australia. The topic of today's podcast is family trust elections and why a trustee of a testamentary trust may now want to consider making a family trust election. To lead us through this startling development, it's my great pleasure to welcome Ian Raspin, who's a partner with B&R Partners. Ian is a specialist in estate taxation and the former chair of CPA Australia's Public Practice Committee. Welcome, Ian.
Thanks, Mark. Much appreciated.
Ian, as I mentioned, today's podcast is about family trust elections, which were introduced around May 1995, so it's almost 20 years ago. So why are we talking about it again?
Yeah, good question, Mark. Look, totally agree with you. They've been around for a very long time, and our practitioners would certainly be very much aware of them and when they're supposed to be made. I think what's not really well known is that there's been a significant change in relation to family trust elections when it comes to testamentary trusts.
Yes.
Which effectively affect the life tenant's ability to be able to claim franking credits post December 2013. Which really puts an emphasis, I guess, on the trustee, as you sort of point out, to consider actually making a family trust election. And today's podcast, I guess, is primarily just to sort of get that message out to market.
Okay, so clearly there's a need to look at it. Before we go into the testamentary trust side, can we have a quick refresher on what the family trust election provisions actually mean?
Yeah, really good call. Look, it's a one-off tax election that's actually made in writing. It's to do with effectively a non-fixed trust, so an inter vivos trust, your everyday
garden variety family trust.
Exactly right, that a lot of our practitioners are actually using.
Yep.
Effectively goes through and limits the beneficiaries to a defined family group of that trust, and therefore for tax purposes treats the trust as a family trust. And
who's included in that family group?
Look, the family group really covers a number of people, fairly wide, but really is the test individual, their spouse, and either of their parents, their grandparents or brothers and sisters, the nephews, nieces or children of both the test individual or their spouse.
Yep.
Also goes on to linear descendants of any of the nephews, nieces or children of either of the above.
Yes.
And effectively any spouses of any of those members in that family group that I've sort of discussed above as well.
And also includes wholly owned entities that those persons own and interposed entity.
Yeah, absolutely right, mate. Absolutely right. Interposed entities obviously needs that additional interposed entity election.
And obviously your family would pick who the test individual is.
A really important place to be making that, yeah.
Okay.
I guess the stinger in all of this, Mark, really comes out that if you distribute outside of that family group, we get hit with what's called family trust distribution tax, which in the 2015 year is going to be 49% given the temporary budget repair levy that was introduced.
And given the breadth of the term distribution, because that can include anything, can't it? Not just money, can include property. That's a bit of a sting, isn't it?
In specie transfers, etc. Absolutely.
So why, given all that risk, would you typically lodge a family trust election?
Well, look, Mark, I guess there's really four reasons for that. Firstly, the ability of a non-fixed trust to actually recoup its prior year income tax losses is simplified when it comes to a family trust election.
Right.
That's primarily because the family trust is not required to meet the 50% stake test, the control test or the pattern of distribution test, which, as you'd totally understand and appreciate, is typically the most difficult test to actually pass.
By far, yeah.
Yeah. Instead, a family trust will only really have to comply with a modified version of the income injection test, which allows a member of the family group to potentially inject income into the lost trust without breaching the income injection test loss rules.
Okay. So that obviously you can do certain things within the family group and not have drama, whereas without the trust election, you would.
Spot on. Look, the second reason really goes through is that a beneficiary of a non-fixed trust is generally unable to access the franking credits on dividends that the trust has actually received and streaming out to that beneficiary if those shares have been acquired post 31st of December 1997.
Okay.
Basically, that's because the beneficiary of the trust is not actually the beneficial owner of those particular shares that the trust owns, meaning that they're not going to be regarded as a qualified person, i.e. someone that's actually been holding those shares at risk for the 45-day holding period rules.
So if you're a beneficiary under a discretionary trust, you've just got an expectancy that you might get something, which is not a fixed beneficial interest, and therefore you in effect you don't meet the 45-day holding period rule.
That's 100% right, mate. wherever, or however I should say, is that where you've got a non-fixed trust that's actually going to make a family trust election,
Yep.
the trustee actually meets the 45-day holding period rules, as it's actually treated as the beneficial owner.
Right.
Should point out, though, Mark, that where there's a small shareholders exemption in the market, so
Yes.
basically where there's franking credits that don't exceed $5,000, there's no need to really do a family trust election.
In working out that small shareholder exemption, that $5,000 threshold, does the beneficiary include all their franking credits, whether they're received directly or via the trust, or is it just the amount via the trust?
A really good point, Mark. It's actually from all of the franking credits, so that actually incorporates any credits they earn in their own name. And if the family trust distribution with the franking credits is going to push them over the $5,000 limit, then we start to get caught in here.
Okay.
Look, the third reason really goes to where the trust actually owns 50% or more of a company, and the company is actually seeking to recoup it's the prior year tax losses under the continuity of ownership test.
Now that's important, isn't it, for small businesses, because family groups, they'll have typically a mixture of company and trust structures, and
Absolutely.
you don't want to rely on the same business test, do you? Because
No.
it's subjective. So if a trust owns the company, which is a bit of has its dangers as a structure, you've really got to rely on the continuity of ownership test, haven't you?
Absolutely right, Mark. And again, that really comes down to, as you're sort of alluding to there anyway, that the beneficiary doesn't actually hold the underlying assets of that particular trust.
Because they don't hold the shares.
Exactly right.
Yep.
Exactly right. So it's very hard for the trust to be able to meet that. However, if there's a family trust election actually made within the trust, the trustee is actually seen to be the beneficial owner of the company, and so the continuity of beneficial ownership tests can actually be met.
Okay. Is there any other reasons why you lodge a family trust election?
Yeah, look, finally, a non-fixed trust, which again makes that family trust election, will not be regarded as a closely held trust under the trustee beneficiary reporting rules. Also, that it won't be potentially subject to the trustee beneficiary non-disclosure tax regime.
Okay, all right. Well, obviously, there's compelling reasons why, as a trustee of a typical, discretionary trust, you lodge a family trust election. However, there's obviously a risk that once the family group is defined, that any distributions to someone outside the group would be potentially subject to 49% family trust distribution tax. It seems to me pretty imperative that you need to actually identify all eligible beneficiaries in the family group, therefore, before you make a distribution. Otherwise, you might get pinged for 49%.
Absolutely right, Mark. You've nailed that very well. It's also really important, though, to point out that the trustee should really also refer to the trustee to ensure that the distribution they're going to be making actually allows that within the terms of the trustee as well.
So we get back to the old furphy, you've got to read the trust deed.
Yeah, pretty
Which
simple.
a lot of people don't like doing, particularly when it was written in 1889 or something and is rather difficult to construe.
Absolutely correct.
Well, thanks for the excellent overview, Ian. I think it's always good to get a refresher on these things. But can we now launch into why family trust elections might be important for the trustee of a testamentary trust and what's changed?
Yeah, absolutely, Mark. Look, as somebody with your tax knowledge should probably recall that the former
Flashery will get you everywhere.
former Howard government back in 20th of March 2006, actually 3 days before my birthday. Look, what the Howard government came out and did is they actually recognised that life tenants of testamentary trusts might not actually be able to meet that 45-day holding period rules that we were just discussing.
Yes.
Primarily, again, because they're the non-beneficial owner of the underlying shares.
Okay.
Just to give a little bit of a recap for our listeners, a life tenant of a testamentary trust is a beneficiary of that trust, and it's often who you see to be the spouse of the deceased.
Yep.
They ordinarily would have a right of income of that trust or a right of tenure, but in this case we'll talk about a right of income from the trust. But they don't actually have any right to the underlying assets or corpus of the trust, and that's often distributed out to the remaindermen, who often are the children.
Yep.
after that particular life tenant's actually passed away. Consequently, where the life tenant's franking credits exceed that $5,000, and we were talking earlier about the combined effect of that in their own name, they're unable to access the credits on any dividends where the underlying shares were required post 21st of December 1997.
31 December, isn't it? 1997?
Actually, correct. Yes, sorry, Mark, that's spot on. Look, the Howard government, as I said, sort of recognised this, and through its then Assistant Treasurer, Mr. Dutton, came out and basically said that beneficiaries of testamentary trust didn't actually need to go and meet the 45-day holding period regime.
Right.
And that actually backdate that particular thing to 1st of July 2002 and passed legislation at that point. The ATO came out at the time and sort of said, well, look, we'll continue to apply the law as it currently is, but there won't be any compliance issues over this until such time as the law was actually passed.
Right, so basically we're working on the basis, and this is the ATO, the announcement would proceed, and we're not going to disallow franking credits because we expect the law to be changed, and that's the administrative practice we'll adopt.
Exactly right.
So I guess in practice, the trustee industry and the tax profession act on the basis that the announcement would be effected.
Absolutely right, Mark, and really I don't really believe there's any reason to believe that it wouldn't be enacted.
Right.
But unfortunately, it wasn't enacted before the current Abbott government came into power.
Yep.
And you'll recall that the Abbott government actually announced back on the 6th of November 2013 that they were going to take some consultation over a backlog of a number of previously announced tax measures.
Yes.
And one of those, to a number of stakeholders, including CPA Australia, and one of those actually included the 45-day holding rules for life tenants.
Yep.
They obviously just over a month and 6 days later, 7 days later.
On a Saturday.
I
remember reading on a Saturday, and what an interesting time to release a press release with bad news.
I actually remember a phone call from you on that day as well, Mark. But look, they came out on that day and confirmed that they would not be actually continuing with the 45-day holding exemption for life tenants.
Yep. So what did that mean? So really from 14th of December 2013 onwards, where are we? Are we back to where we were when Minister Dutton's, or before Minister Dutton's announcement? Were we back to pre-20 March 2006?
Absolutely right, Mark. We're in that place. Fortunately, the government actually went through and passed some legislation which provided some protection for the taxpayers that had reasonably relied on that 2006 announcement.
Okay.
And look, from a practical perspective, that really covers the period 20 March 2006, the date of the initial announcement, up to the 14th December 2013.
Yep. So what does it mean? Okay, well, that's a big change, isn't it? So for trustees of testamentary trusts doing income tax returns for the year ended 30 June 2014 and beyond, where are they?
Yeah, look, they're in a really difficult sort of position, I guess, Mark, and I guess that's what that change is what we're trying to make this podcast really about. Unfortunately, it wasn't really widely promoted, and we're seeing a continuance of life tenants actually continuing to claim franking credits as they always have over all these years,
Yep.
But now obviously are doing so incorrectly.
Okay.
Really be necessary for the trustee to go through and apportion those franking credits that they received on or after 14th December 2013 and provide the beneficiaries of that particular split.
Because I guess some dividends will be okay and frankable for the first half of the year, broadly speaking, and the second half they won't be.
I think that's right, Mark, but it's really got to be demonstrated that they'd relied on that 2006 announcement up to that particular date in time for that to be able to happen.
Good point. Okay.
Yeah. I guess secondly, that the trustee really needs to sit back and assess if they really should lodge a family trust election, and in fact are even able to, and really up the way the benefits of doing so against the negatives, like inadvertently triggering that family trust distribution tax.
Yeah, I would think that triggering family trust distribution tax is a real risk. If there are, would happen, wouldn't it? If there's life tenants or remaindermen outside the family group, that'd be a bit unusual, but it could happen, couldn't it?
Oh, absolutely right, Mark. Absolutely right. And look, I think it's really important that when trustees are actually assessing whether they're going to make a family trust election or not, that they really assess the terms of the will, try and identify who the beneficiaries are. It could be, and they really may find they may not be able to meet that family control test. It's something I really don't envy them. It's not really clear cut, and there are some serious long-term consequences.
Okay. So what happens if the trustee determines they can't make a family trust election?
Well, I guess, Mark, there's a series of administration issues come out of there. I mean, firstly, I guess the trustee's got a responsibility to actually advise the beneficiary that a family trust election could not be made, and that the beneficiary may therefore not be able to actually claim back the franking credits if they're above the $5,000 mark in their own return again. Again, assuming that small shareholder exemption doesn't apply.
Well, I imagine this wouldn't go down well with a vulnerable 85-year-old widow who's been used to accessing franking credits, and now you have to go to a retirement village and say you ain't got them anymore. I suppose it's not particularly easy. It's not easy,
and they're somewhat dependent on those, Mark. And look, I think trustee companies and trustees around the country really got some real work to do and appeasing these beneficiaries.
Yep.
So it doesn't appear to be their responsibility and their fault, but also educating the beneficiaries about the significant change in this landscape.
Okay. Well, and you previously mentioned there's some potential underlying issues with making a family trust election within a testamentary trust. Could you give us a couple of examples of the sort of things you're seeing and hearing within the trustee industry?
Yeah, look, absolutely, Mark. Look, a couple of examples that sort of come instantly to mind would be where you had a life tenant of a testamentary trust that was, say, a good friend of the testator, not a family member, but a good friend, and that on their passing, the residual assets actually get passed across to the family. The problem is that good friend is outside the family group, so it really puts the trustee in a situation to say, well, do I or don't I actually make a family trust election at this particular point in time, because one of the beneficiaries is outside the group, and that penal 49% tax is sort of on the table.
It's half of it, isn't it?
Absolutely. I guess the other one that really comes to mind is, and one that a number of very respected advisors in the marketplace have been talking about, is where the remainder beneficiary actually passes away before the life tenant.
Right.
But that remainder beneficiary has, say, present entitlement or absolute entitlement to the estate assets.
Yeah.
What would appear to be the problem there is that the estate of the remainder beneficiary is not going to be caught by the family group provisions.
Okay.
Which again sort of raises a problem around family trust distribution tax. I'm really not sure how somebody within estate planning actually goes through and foresees those sort of problems.
Well, Ian, thank you very much for coming in today and going through that issue with us. It is a big sleeper, and I'm sure our listeners appreciate the fact that you've highlighted it to them, and that clearly that it's a complex matter that they need to address. Thanks again for coming in.
Thanks, Mark. It's always a pleasure.
To learn more about this topic and our range of professional development options, including conferences, workshops, self-paced learning, webinars and in-house training, go to cpaaustralia.com.au/training. The information in this podcast is not advice. Any opinions expressed are those of the individual and do not represent the opinions of CPA Australia. You should always make your own inquiries before entering any transaction on the basis of the content of this podcast. CPA Australia will not be held responsible under any circumstances for damages arising from any use of this podcast.